Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on issuing of notices under section 148. The issue before Ahmedabad ITAT D bench was that if the notice is being issued to the assessee on the basis of information from the investigation wing, and even if the investigation wing has not recorded any satisfaction that what is the impact of that information on the income escaping assessment of the assessee, and the assessing officer just by copying and pasting that information in the reasons issues the notice to the assessee. So whether in that case the assessment based on this type of exercise is valid in the eyes of law as far as section 147 assessment proceedings are concerned. This issue has been taken up by the Honorable Tribunal in the case of Khajana Stores Private Limited versus Income Tax Officer, and this case is reported in 133 ITR Tribunal, short notes 36, and the date of the judgment is 23rd December 2025. The present case relates to the assessment year 17-18. In the present case, the assessee has filed a return of income of rupees 48,99,470. It is the normal feature of the assessee that the assessee deposits the cash into his bank accounts. The present case relates to the assessment year 17-18, and the assessee has also deposited a cash which was higher, which was alleged in the present case. The assessing officer received the information from the investigation wing that the assessee has deposited a cash of rupees 4 crore during the previous year relevant to the assessment year 17-18. In the investigation report, there was no mention that how that cash deposit will affect the income escaping assessment of the assessee, and the assessing officer simply copying and pasting that information into the reasons mentions that the assessing officer has reason to believe that this income has escaped assessment. When the assessment proceedings were going on, the assessee challenged the notice, but the assessing officer upheld the validity of the notice and observed that in the case of the assessee, the cash deposited during the month of November was higher than the average cash deposited in the other months which were relating to that previous year, and accordingly the assessing officer made an addition of rupees 59 lakh, which was being upheld by the CIT appeal. When the matter was heard by the tribunal said that in the present case, the actual cash deposited by the assessee was 2.47 crore and the allegation was 4 crore. So it is very apparent from the assessment proceedings and the reasons that the assessing officer has issued the notice just on the basis of the information received from the investigation wing, and the assessing officer did not try to correlate the cash deposit with the income of the assessee, because in the reasons the assessing officer has not even mentioned that what was the returned income of the assessee. The tribunal said that in the present case, the cash deposit in the previous years was also more than the cash deposit in the current year, so it was a regular feature of the assessee. If the assessing officer would have correlated the cash deposit with the returned income of the assessee, then he should not have made a belief that the income of the assessee has escaped assessment. The tribunal said that the requirement of section 148 reasons is that there should be there should not be subjective satisfaction, and the satisfaction should be objective. The tribunal said that reason should have been held in good faith and could not have been merely on pretense. The tribunal said that the reason to believe should have relevant bearing on the formation to believe. The tribunal was of the view that the power under section 148 is very wide, but it is not plenary power. The tribunal said that the assessing officer should not act on suspicion, gossip or rumor, and in the present case, since the facts on the basis of which the notice has been issued are totally wrong, because the actual cash deposit was rupees 2.7 crore and the cash deposited allegation was of rupees 4 crore, so the very basis of reopening was not correct, so the assessment should be quashed on this ground alone. At the end of this video, once again I am repeating the name of the case. The name of the case is Khajana Stores Private Limited versus Income Tax Officer, and this case is reported in 133 ITR Tribunal, short notes 36, and the date of the judgment is 23rd December 2025. Thank you, friends.